I'm Nan Aron, President, Alliance for Justice, which is a national association of over 100 public interest civil rights advocacy groups. We have just had an hour of an amazing conversation with Senator Elizabeth Warren and Judge Nancy Gertner about the critical importance of professional diversity on our federal bench. We find ourselves at this wonderful moment in time where the filibuster has been eliminated for judicial nominees, which makes it possible for the president, for the Senate, for public interest groups, and for all these nominating commissions around the country to identify and recruit public defenders, civil rights lawyers, worker rights lawyers, public interest, people from the entire scope of work for judgeships. We've explored with Judge Gertner her views and heard some wonderful reflections from her. It's now an opportunity to bring into the conversation Sherrilyn Ifill, who, just like Judge Gertner, has a wonderful background. She was a law teacher, a litigator, and is now president and director counsel of the nation's most important legal advocacy civil rights group, the NAACP Legal Defense and Educational Fund. Sherrilyn will start off and share some of her thoughts, but I would just like to ask right off the bat, Sherrilyn, how do you see professional diversity enriching decision-making that takes place at our federal courts?
So Nan, thanks so much for the introduction and for having me, and Judge Gertner as well. You know, I began writing about judicial diversity 20 years ago, and I came to it from the perspective of a civil rights lawyer, and I came to it thinking about racial diversity and gender diversity, and I've spent 20 years writing about judicial diversity. And what I wanted to grapple with was precisely the question that you asked. I wanted to get away from the idea that we should promote diversity because it's nice to have a bench that looks like America. I think that's soft, and I didn't like it. I really wanted to explore the idea that a diverse bench actually enhances judicial decision-making. That in order to invest people in the idea of diversity, we should not be investing them in it because it's a nice thing to do for Black people or Latino people or women, but because it gets us the best kind of judicial decision-making we can get. And in fact, I wrote a law review article called Racial Diversity on the Bench, Beyond Role Models and Public Confidence. And I wrote that article in like 2000. So I'm really thrilled to see people taking up this issue in the context of professional diversity, because round about 2005, I started focusing on that form of diversity as well. And I'm so thrilled that the Alliance has just stayed with this, because really now is the moment where I think we can see the importance of professional diversity. Let's take the United States Supreme Court. So we're all familiar with the arguments about diversifying the court, right? We talk about racial diversity on the court. We talk about, when Thurgood Marshall stepped down, having another African American. We talked about women on the court after Sandra Day O'Connor stepped down. But I think we have paid too little attention to the role of professional background diversity, even at the level of the United States Supreme Court. When you read and listen to Justice Stevens, who stepped down from the court several years ago, talk about his background and his experience, you recognize that there is now no one sitting on the United States Supreme Court who was an active duty veteran. And it turns out that that's not irrelevant to judicial decision-making. In fact, some of the most important decisions with which we credit Justice Stevens of the last 10 years are the decisions that relate to actions that the Bush administration took following 9/11. And it was Justice Stevens in the Rasool case and in other cases who said, wait a minute, there's a way we treat people who are prisoners of war. And in a New Yorker interview, he talked about his experience as a cryptographer during World War II, where the worst of the worst, right, were entitled to certain kinds of protections. And so in his mind, the way he thought about even people who had done terrible things in war, how they ought to be treated was very much shaped by that experience. We talk about Justice Sotomayor, and you remember the wise Latina controversy, right? And so we laud the fact that she's the first Latina Supreme Court justice, which is fantastic, and that she's another woman on the Supreme Court, and now we have 3, which is terrific. But if you read some of her jurisprudence, what you discover is that she has a very unique perspective, particularly in criminal justice cases, forged by her experience as a city prosecutor in the Manhattan DA's office. So I don't think that Justice Sotomayor holds any brief for Jeffrey Skilling, right? The man who was convicted in the Enron case. But when his conviction was overturned, it was only Justice Sotomayor who expressed her very deep and eloquent concerns with how the jury was selected in that case. She's done voir dires. And when she heard that the voir dire for the jury in that case in Houston took only 2 hours, and she saw some of the questions that were asked and the answers, she had a very specific, pointed reaction to the way that voir dire was conducted, which came from her experience. I think we're at the point now on the United States Supreme Court where Thurgood Marshall is probably the last justice who represented a criminal defendant at trial, certainly who represented a capital defendant at trial. And yet think how many habeas proceedings and capital proceedings end up before the United States Supreme Court, a very special and particular kind of litigation that carries with it lots of different details and permutations. When Justice Marshall stepped down from the court, what Justice White and other colleagues said was that Justice Marshall told us things we knew but didn't want to know. And most of the stories that they refer to are the stories that Marshall told about his years as a litigator, as a lawyer for the NAACP Legal Defense Fund when he was directing the organization, and the experiences he had with juries, with Southern juries, with criminal defendants, with discrimination in jurisdictions in the South. So he brought the wealth of his background as a lawyer, not just as a black man, but as a lawyer representing defendants, criminal defendants in racialized contexts. And he brought that into the conference room to share with his colleagues so that they could have a different window into the cases that they're deciding. And so without that professional background diversity, without criminal defense lawyers, without lawyers who have represented those who've been discriminated against, without lawyers who have a background in, at state courts, right? We don't have state court judges anymore. Justice O'Connor and Justice Souter were the last 2 Supreme Court justices who had sat on the state bench. Without that kind of diversity, we're actually missing in the conference the kind of give and take and information that I think is essential. And so I think it's incumbent upon those of us who have advanced appropriately so and continue to advance the importance of racial and gender diversity to also recognize the importance of professional background diversity. Listen, being on a court, being a judge is an elite profession. You are a small percentage of the population of this country. You're also a small percentage of the legal profession. But when we begin to look at, as you document in the report that the Alliance released, the background of the judiciary, we're talking about even a small percentage of the background of the legal profession. So we're getting to the point where we're talking about a very narrow slice of the legal profession in terms of the professional background that actually is deciding cases that affects the lives of everyone in this country.
There's a wonderful story that I think Linda Greenhouse tells about the Lilly Ledbetter decision that you refer to a little bit in the report, which is the Lilly Ledbetter decision had the majority of the court saying that the statute of limitations, you had to begin to sue once the decision about your salary was made. That's when you had to do it, rather than when you found out about it. And I think it was Linda Greenhouse's point that when you looked at the bench that decided that, with the exception of Justice Ginsburg, they all had been in public employment. where salaries are public. They did not understand private employment where nobody knows what the guy next to him is making. And so they brought that notion to the table. It's also one of the experience of judging is that facts are not isolated things. Everything is about the context. And if you are not interested in the context, if you have nothing to add to the context, the decision-making is different. In the Ledbetter case is a classic example. If you knew the context in which this was taking place, you could not have said the things that the court said. So experience makes an enormous, enormous difference.
Well, you'll remember just last year I wrote a piece in the National Law Journal about it, but it was a case that occurred a couple years ago where a panel of the 11th Circuit Court of Appeals in an employment discrimination case essentially found that a white supervisor calling a black employee, adult male employee, boy, was not racist and had no racial context, right? So, I mean, there are these just kind of extraordinary moments, and if you, as we do in our organization, litigate discrimination claims, I mean, there are two pieces at work in the discrimination context. First of all, to accuse someone of racial discrimination is a very serious charge, right? It's something we don't want to believe. We're hardwired to look for all the other possible explanations before we land on discrimination. And, you know, in a way that's appropriately so, because that's a reflection of the success we've had in stigmatizing racial discrimination so that we recognize it as a stigma that we don't want to impose on people lightly. But it's also true that part of the success we've had is that racial discrimination now takes very different forms, right? People know that it is socially unacceptable to be blatantly discriminatory. And so now you really do need judges who have some experience, who are willing to make the inferences, the relevant inferences, who can understand the context that you talked about.
Or let a jury make the inference.
Or let a jury make let the case at least go forward to let the jury make the inference. This is why things like the Supreme Court's decision in the Iqbal case, right, which heightens the pleading standards, is so troubling, because every time we kind of close the gate, we're essentially removing the possibility that others who have the relevant experience to be able to correctly interpret the context will have a chance to hear the case and understand the case.
Well, you know, the discrimination law is also so interesting. The numbers of judges and numbers of opinions across the country saying, for example, that this race discrimination or gender harassment or race harassment was not severe and pervasive. This is a judgment call that as to which it matters who's on the bench. What is severe and pervasive to me is different than what's severe and pervasive to the guy in the courtroom next to me who perhaps had never experienced discrimination. You know, there's a concept in discrimination law known as stray remarks. And I am appalled at the numbers of N-word cases in which stray remarks were found. Well, what remark is stray, dismissive, trivial is not a judgment that this bench ought to be making rather than a jury, particularly not a bench who made up of the bench that we have. So again, they're judgment calls at every moment in a judge's life, and you want to make sure that those judgments are exercised by people who at least know the world.
So I have a question. So later on today, when we put this interview on our website, and I know it's going to be looked at by law students from around the country who participated in this morning's conversation, we say to, for instance, civil rights lawyers, think about yourselves. Think about your becoming a judge. We say to law students, think about a career in civil rights work. Certainly Judge Gertner touched on this morning. But we want people to become public interest civil rights lawyers. We say go out, be courageous, take on difficult cases, speak your mind. But we also know how difficult the nominations process is, and we're all aware of the realities of the political process today. How do you square what you say to young lawyers with what they will face if they decide to pursue a federal judgeship? Actually, both of you.
Well, I think we have something very encouraging to say, right? Because it's a process. if this were 40 years ago, we could be saying the same thing about women, right? So the process that we're in, that you're making an enormous contribution to, is a process of shifting the way people think about who is available to sit on the bench. One thing I absolutely credit the Obama administration with is their willingness to look at people who were criminal defense attorneys, public defenders, which for a long time had kind of been in the wilderness. Basically, the track to be a federal judge was you had to kind of be a U.S. attorney and then be a judge and then be a judge again, right? And so I think the Obama administration's done an amazing job of beginning to open it up to former public defenders and criminal defense attorneys, which now says to them, right, you should apply. You should throw your hat in the ring. And I think as we begin to open up that conversation, it's going to transform things. Now, it's not just a discussion. There are real decision moments and structure moments that we have to deal with. We have to get this message out to judicial nominating commissions at the state level, right? Because there's a pipeline that comes all the way up through the process. We have to get this message out to bar associations, right, who are very involved in nominating, vetting, and so forth, judges. And then, of course, to the very selectors, to the United States senators, to the president, whoever he or she may be, to governors, when they get that list, right? The list, we've now got people to the point where they look at the list and they say, well, there's no women on it. Where are the racial minorities, right? So that's what's successful. Now we've got to get to the point where they say, well, wait a minute, these are all former prosecutors, right? Where are the civil attorneys? Where's the solo practitioners? Where are the right? To begin to ask those same questions and say, go back and bring me a list, right, that is more diverse. So it's not just a conversation that we can have. We really have to take this message on the road out to those decision makers who really are involved in the process of selecting judges at the state and the federal level. You got to start with the farm system. I think you got to start at the state level and you change the culture. And you bring it all the way up. And at each of those decision points, we've got to be pressing this argument. And the key to pressing the argument is not because it's something nice to do, right? But because our job is to get the best kind of judicial decision-making that we can get. And the best judicial decision-making, I believe, and what I've been writing about for 15 years, is decision-making that's informed by all of the relevant, appropriate viewpoints, backgrounds, experiences that will produce the most informed decision-making.
I can't say much more than that. I mean, I think that you ended on the note that I wanted to start with, which is that it's not, as you said before, not just a question of having a bench that looks like America. That's very nice. That's very important. But one could go through a judge's day in all of the 1,000 decisions that you make. How much time to give to this argument? Do I hear from the other side for how long that essentially are decisions prejudging substantive matters, prejudging what the issue is? I remember when I was writing sentencing opinions, and I would write lengthy sentencing opinions because I thought that the sentencing guidelines needed to be critiqued and needed to be rigorously evaluated. And a judge would say to me, I really ran into a judge who said to me, you know, you're going to require that we spend more time on sentencing than we do on summary judgment. I said, just so, right? Liberty damages. Is there an issue? But it was clearly his view that I was making sentencing too complicated and he was now going to spend too much time on it. That is a judgment of someone who's never seen the inside of a prison. That's a judgment of someone who doesn't know the consequences of conviction. And it was arguably a procedural judgment masquerading, it was a substantive judgment masquerading in a scheduling issue. And it wasn't a scheduling issue at all.
I have a final question, but before I ask, is there, particularly Sherrilyn, anything else you would want to add to this discussion?
Well, only that I think we're at this critical moment where this issue has to be elevated. I was really pleased to hear Justice Sotomayor make a comment about this a few weeks ago, because I think it means it's saturating it's permeating the culture. People understand it makes a difference. And I think when we get to the point of, I constantly talk about the Supreme Court because I feel like that's a reference point people can understand. And while they're all very smart, when you look at a Supreme Court that is that heavily weighted in the favor of people who've been former U.S. attorneys, and people who have, as you say, have only worked in the public sector. You have to wonder at some point about what could be missing, right, from the conference. And I do think it's important. In the article that I wrote called Judicial Diversity, it's can be found on Greenbag. We'll have it on our website, and I'll make sure you have the link as well. I talk about how at the confirmation hearings, the justices, soon-to-be justices, always start out by telling their personal story, and they start out and they say things like, Justice Ginsburg, I'm a Brooklynite born and bred, or Justice Alito, who talks about, his immigrant family and so forth. So they try to give their background, right, as a way of saying, this is who I am and why you should trust me, in this job. I do wish that the Judiciary Committee, which is the other pressure point, right, that within their question should be embedded a set of questions that go to this question of background diversity. Because even in your chosen profession, you have the opportunity to do many different kinds of things. Right. So it's not just like, is this person a criminal defense attorney? Is this person a prosecutor? Is this person a civil rights attorney? The array of things that you have exposed yourself to, it seems to me, are critically important. And I almost never hear those questions about the boards that you sit on, the pro bono work that you've done, the volunteer work. We want to know. Round it out for us. If it's not clear from your, the job that you had, show us that you have been exposed, right, to the world. But I think in the context of the profession, we should want to have a bench that really has this mashup of many different people who can bring something to the table and who can say, but what happens in those cases is this. I tried 20, 30 of those cases, and what usually happens is this. If I'd never practiced in that area and I'm a judge, that would help me. That would help me evaluate what I'm seeing. Why wouldn't we want that to be part of the material that judges have when they're making these incredibly difficult decisions at the volume at which judges are working, right? They've got this volume of cases. And to be able to make the decisions within the decisions, right? Judge Gertner just talked about, the trial judge, which constantly gets ignored. Trial judges make hundreds and thousands of decisions that go unreviewed, which, she just described, like how, whether I'll hear from the other side, how much discovery I'll allow, whether I'm going to hear argument on this motion. I mean, there's all kinds of decisions that they make that go unreviewed. And we should be helping them, that's how I like to put it, have more information.
It's interesting you say that because, as you know full well, nominees hide from their past. I recall a hearing when David Souter, who had spent his whole life in New Hampshire, was up for being elevated from the First Circuit to the Supreme Court. It was either Herb Cole or Paul Simon who asked him whether he had ever lived on an Indian reservation. And I remember the room just became totally silent. Like, where did that come from? But it represented, I think, those senators' desire to learn something about the person beyond the resume or beyond what the White House wanted.
Yeah, but the better question would have been about his experience as a state court judge. Mm-hmm. Right, because that's the diversity. It didn't seem like diversity, right? He's a white guy. He's only lived in New Hampshire, right? But he actually was bringing something to the bench, and what he was bringing to the bench was that he'd sat on a state court, and there were no real questions about, the process of state court decision making or the way in which state courts interact with legislatures. Or, the cases that come to the Supreme Court very often are cases, right, based on state law, and they come from the state Supreme Courts and so forth. It seems to me he had something to share that was left on the table. Or Justice O'Connor to ask about elections, right? When they later had to decide Republican Party of Minnesota versus white, she was the only person on the bench who'd actually understood, the election of judges and so forth. Didn't think her decision necessarily reflected that, but nevertheless, that's the kind of material, that's another discussion, that's the kind of material I think the Judiciary Committee should be interrogating. They should be looking for what is it you bring to the bench. It was, the wise Latina stuff was obvious, right? But, the stuff about being a prosecutor in Manhattan strikes me as pretty important, right? So the questions that came up in the Skilling case about selection of juries, how much time we spend on juries, the issue of Batson. I mean, there are really important, critical constitutional issues involved in jury selection, which probably she knows more about than anybody currently sitting on that bench.
So last question for both of you, although it's pretty obvious listening to you both. What keeps you going? This is hard. We've seen the courts change so dramatically from the 60s and early 70s when people at the margins, disenfranchised individuals, underrepresented people turned to the federal courts, and we now see a federal judiciary largely unresponsive. Totally unresponsive. What keeps you both going from a personal perspective?
Progress. I mean, you remember, Nan, the old Fourth Circuit and the effort to diversify the Fourth Circuit, right? You had, a circuit that covered 4 states, right? Is it 4? South Carolina, North Carolina, 5, West Virginia, Maryland, and Virginia, that had never had an African American sit on the Fourth Circuit, ever. And, this was in the 1990s, and you remember how we grappled with that issue. And yet now the Fourth Circuit, has multiple African Americans sitting on it. And the idea that you talk about racial and gender diversity is no longer like this weird fringe thing, right? Everybody it's a mainstream conversation. So really what keeps me going is, you got to have strategy, but you have to have patience. You have to do really what the Alliance does, which is stick with this for the long haul, because then you get to see the arc of the thing, that you change the conversation. And we're doing it right now. 15 years from now, people will think it's perfectly normal to look at a bench and say, well, wow, I'm looking at the Fourth Circuit and, we need more background diversity. We don't have any, that will happen. So what keeps me going is the ability to stay with it. And the trick is staying with it because you need the institutional memory. You need the people who remember what it was like on the front end and how you got there. No, I'm saying seasoned.
Okay.
So that's what keeps me going, that you actually do change the culture.
I also think that very few things are as important as this. Someone asked during the public session about, my background as I talked about my background as a litigator. What was wonderful about those years is that I knew that there was a place to go, which was a court, where I could speak about rights, where I could represent the powerless, and I then knew or believed that they could have a hearing that was a meaningful hearing. And when we lose that, we lose an enormous amount. So what keeps me going is really the desire to make sure that that place, in some sense, is restored or was as we remembered it, which is where people can exercise their rights and where they'll be listened to, and not the case dismissed because you know that if you dismiss it, you'll be affirmed by your Court of Appeals and your statistics will look good.
I just have to add, because what you said is so powerful and so true. What is absolutely true is beyond my believing in that forum is how much my clients believe in it. I mean, there's nothing I can tell my clients. I've had cases where I've said, listen, this is the judge we drew. It doesn't look good, right? So, it's probably not going to work out. And they just believe.
Right.
And I've had cases which I knew were fantastic, and they were dismissed, right? And I just feel terrible. And without fail, my clients always say, no, we had our day. That was the first time in open court somebody told our story, right? Their belief in that forum to vindicate is so contagious, so powerful, such an enormous responsibility that I thoroughly agree with you that place, preserving that place, and my client's confidence in that space, it's so moving and so important, and it very much is the engine that kind of churns the commitment to trying to maintain that place as a place where rights really can be vindicated.
Well, thank you both so much. This has been a treat. It's been a marvelous, marvelous conversation. And the best part is that we can share it with people who come on our website, and we will do our best to get it around. You two are just sensational. So thank you so much.
Thank you.